Good afternoon, everyone. Welcome to the second part of our two-part series on the EU Whistleblowing Directive 1 year on. And the aim of these sessions is to help businesses with a presence across Europe to understand how the Whistleblowing Directive affects them and whether or not there really is a one-size-fits-all approach when it comes to different jurisdictions. My name's Christina Hutchinson. I'm a Senior Associate in the Employment team at Fieldfisher UK. I'm also a key member of Fieldfisher's whistleblowing team, so I'm really excited to be here today chairing this panel. If you're able to join us last time, we had a similar panel discussion, but with countries where the EU Whistleblowing Directive has already been transposed into local law, and that panel was chaired by my colleague Nick Thorpe, and we heard some really interesting thoughts across Europe, including from France, Belgium, Sweden and Ireland. And today our focus is going to be on those jurisdictions where we have not transposed the directive yet, but it's imminent. And I think to date there's only around half of the member states that have transposed the directive into local law. And very recently, the European Commission has actually referred 8 member states to the European Court of Justice for failure to transpose the directive. So today's session is very relevant. And of those member states that have been referred to the Court of Justice is Italy and Germany, who we're going to hear from today. So before we start our discussion, just some housekeeping rules. Today's session will be recorded, but we will share the recording with you after the session. We're going to try and make the session as interactive as possible. So if you have any questions along the way, drop them in the question box and we'll address them at the end if we have time. So it was a great pleasure for me to introduce our panel today. So first up, we have Talmac Bell. He's a partner in our Spanish office. He's also head of employment, pensions and immigration in Spain. Talmac advises on all aspects of employment law, and he has a focus on international and cross-border matters. Next we have Frank van Uden. Frank is a partner in the Netherlands and based in the employment team. He's a recommended lawyer in Legal 500 and also Chambers Europe. He's also written a book on whistleblowing, so he's really well placed to talk to us today. Next up we have Marcus Isk. Marcus is a labour lawyer in our German office with cross-border project experience. His main focus is negotiations with works councils and trade unions, and he's a member of the Working Committee of Certified Specialists for Labour Law of the German Bar Association. And last but not least, we have Luca Antonetto. Luca is a partner at Fieldfisher Italy and specialises in labour law, trade union and social security law, as well as corporate criminal liability. Luca prepared a position paper on the transposition of the directive into Italian law, as well as being involved in the parliamentary consultation on the transposition. So again, really well placed to talk to us today. So welcome everyone, thanks for joining us today on our panel, and we'll just get right to it, I think. So first question, how much awareness is there for protection of whistleblowers in your jurisdiction? Has that changed since the implementation, since the directive came into force? Has it resulted in greater awareness? Any general comments on the directive? I think first we'll come to Talmac. And Talmac, I know we said this session today is about those jurisdictions that are yet to transpose, but I know Spain has actually transposed it this week, so let's talk about that. I think you're still on mute, Talmac.
Sorry about that. I was just saying, yes, we have a Whistleblowing Act that was published 3 days ago. And well, it comes into force on June 13th. I mean, it comes into force. There's a transition period to which that will allow companies to adapt until June 13th for those companies with more than 250 employees. For companies between 50 and 150 employees, the deadline is December 1st. So we finally have the directive transposed. And yes, this has definitely been a game changer in Spain from a whistleblowing perspective, because the whistleblowing concept or notion is very alien to our legal system. We had whistleblowing channels because of the compliance regulations, and this is something that big companies had already put in place much before the coming into effect of the directive. But I must say, people didn't know the word whistleblower or the Spanish equivalent. And we even had to create a word in Spanish because we didn't have a very accurate translation of whistleblowing or a whistleblower. So this is very new in Spain, and definitely the directive will have a huge impact and has created a great degree of awareness, and will have also a huge impact in our legal system, and particularly in employment relationships. And this is going to be very relevant, we anticipate.
That's really interesting. And Luca, what's the position in Italy? Italy is one of the countries that has yet to transpose it and was delayed in the deadline of the December 2021 deadline. How's Italy looking?
Thank you. First of all, I'd like to point out that in Italy we already have whistleblowing legislation since the end of 2017. Nevertheless, the awareness is not so widespread. The awareness is rather uneven, at least in private sector. It's quite widespread in large companies, less so in small and medium-sized companies. This is due to the fact that the scope of current whistleblowing legislation coincides with that of the Legislative Decree 231/2001, laying down the discipline of the administrative liability of legal person, which in turn calls for the adoption of an organizational and management model in order to be exempted from such a liability. But the adoption of that model, including whistleblowing channel, on one end is optional, and on the other end may be quite expensive. This is why it has been mostly large companies that have adopted it, while smaller companies have often given up on it, thus cutting themselves off also from the establishment of whistleblowing channels. Furthermore, there's a tradition in Italy. From a cultural point of view, Italians are reluctant to report crimes for fear of looking like snitches. So therefore, the number of reports is relatively low, even if in the recent years it has steadily grown. I think that things are going to change quite a lot with the implementation of the directive, which is expected in a few days in Italy. There's a draft of legislative decree was approved by the government on 9th December 2022, and the parliamentary process in which I was involved for consultation ended at the end of January. So we are just waiting for the promulgation and the enactment of the new legislative decree transposing the directive.
That's really interesting, especially the different approach from a cultural perspective. And Frank, how about the Netherlands?
Yeah, thanks, Christina. So the directive was finally implemented into Dutch law last Saturday, so only a few days ago. We've had whistleblowing laws since 2016. And in addition, employees can rely on case law from the European Court of Human Rights in Strasbourg, which tends to be quite protective of whistleblowers. And in terms of awareness, the reaction to the directive has been relatively muted. So it's not considered a huge deal generally. And that is probably because the directive does not introduce something completely new, but only amends existing legislation. The bigger picture is that most employers recognize that whistleblowing, if properly managed, is a useful early warning tool, which allows them to swiftly rectify potential wrongdoing. But the general perception among employers is that the directive will only complicate existing rules and will make it much more difficult to properly manage whistleblowing.
Thanks, Frank. And Marcus, I know Germany is also on the European Commission's naughty list. What's the outlook over there? How was everyone feeling about it?
Thank you, Christina. Yeah, it's actually true. And unfortunately, Germany is currently going to stay there for a little more, because even though the German Bundestag passed the law to transpose the directive into German law, the Bundesrat, which is the, let's say, parliament of the federal states in Germany did not pass it. And that was just recently on the 10th of February. So they said no to the current draft. That means that, yeah, they have to go back to a conciliation committee to find a compromise solution so that the directive can finally be transposed. On the one hand, this is of course no good news because there will be a further delay. On the other hand, talking about the awareness, the fact that the Bundesrat denied the approval gave quite a lot of awareness in Germany to the fact that the whistleblowing directive is going to be transposed into German law. And similar, like in Italy, the bigger companies were already aware of it before, while the smaller companies there we recognize a lack of awareness still. But yeah, I think we still have a bit of time, and until we have the final law, this will hopefully be all fine, that all companies knows what is coming up.
Yeah, so watch this space for Germany. Okay. And so for our next question, can you explain how the directive will change national laws? And can you just give one or two examples of how that will be the case? So Tamak, I'll come to you first again.
All right, I was on mute again. Yes, of course. It's and in Spain there's something which is change. I mean, it is a change that we have now the whistleblower, and that we are all very aware of the existence of the whistleblower as a legal figure. But one thing that existed before the whistleblowing directive was, of course, internal reporting. But this internal reporting could not be anonymous. So this anonymity is a big change. It's something that will have that will make this reporting to give it a different dimension in Spain. And what is also very interesting is the consequences that this internal reporting will have from an employment perspective. In Spain, obviously the whistleblower will be protected. It was somehow protected before it was considered a whistleblower in the sense that the employer could not terminate the employment contract or retaliate or sanction the employee due to or as a consequence of internal reporting. But that was not very clear. There wasn't much case law on that point. We anticipate, although this is not made clear in the Spanish Whistleblowing Act, we anticipate that it is going to be much more likely that the termination of a whistleblower is declared null and void in Spain. This has important consequences because, as some of you may already be aware, in Spain, when a termination is not lawful, it can be declared unfair, in which case there is a severance compensation that needs to be paid. But in cases of discrimination, or when the employee is under a protected status in case of pregnancy or other similar cases which are protected per statute, under those circumstances, the termination will be declared null and void, which means that there's a fiction that the termination never took place. The employee must be reinstated, and salaries must be paid from the termination date until the date of reinstatement. This is now something that will trigger, in our opinion, in the view of employment lawyers, will incentivize many employees to report, because this will become a very effective way to protect themselves from termination. And eventually, if their contract is terminated, this will enhance their position in a negotiation that has to do with that termination.
That's really interesting. It really shows, I guess, how important the protection for whistleblowers is if we think Spain's going to go that far. And Frank, how about in the Netherlands?
Yeah, so here the biggest change is how employees should report potential wrongdoing. Under the old law, they were required to report wrongdoing internally unless that was clearly unfeasible. And under the new law, employees can choose. They can either report wrongdoing internally as before, or go to an external regulator, for example, the Financial Markets Authority. And in addition, the new law leaves employees quite a lot of freedom to go public. For example, if they can reasonably believe that their employer or a regulator will not efficiently address the wrongdoing. It's of course a huge potential liabilities if employees go straight to the media.
Thanks, Frank. And Marcus, are we able to comment from a German perspective yet?
Well, it's a bit difficult because the law or the draft law has been just taken off the table. But anyway, so one of the biggest changes is that companies with more than 250 people I have to say, but I think not that much will change in the new draft law, have to implement whistleblowing hotlines, external ones, internal ones. And just like in Spain, employees are who report any wrongdoing are protected from any negative employment law related effects. So this will be seen in the future how strong the protection will be, what consequences employers might take. Or will be seen as a consequence due to whistleblowing, and will not be accepted. So we will see in the future. Unfortunately, I cannot give too much information on the points yet because we do not have the final draft on the table, but it will come, and it is important that we have the reporting hotlines and anonymous hotlines as well, that we give the opportunity for employees to report anonymously.
Yeah. Okay, great. And Luca, can we comment on changes from an Italian perspective?
Yes, from an Italian perspective, there will be quite important changes. The first of all is that the establishment of whistleblowing channels with all the related safeguards will become mandatory for all legal entities which in the last year have employed the average of at least 50 workers, which is not the case today because as I told you before, the only companies optionally adapting organizational model now are obliged to have whistleblowing channels. The second big change will be the material scope of whistleblowing system, which will be much broader than that of the current law. And finally, even the personal scope of application will be much broader. So big changes are expected in Italy, even if we already know, if you already have whistleblowing legislation that is going to be implemented quite a lot, and companies we are going to face the difficulties mainly in the coordination of the new system with the old system of whistleblowing, and secondary in changing of whistleblowing management procedures and the related privacy obligation, which could be very tricky.
Okay, so it sounds like there's a few changes coming in Italy. And so the directive, as we know, sets out minimum levels of protection in relation to whistleblowing and also standards. But we know from our previous session that Nick chaired that many countries have actually gone beyond the directive in terms of their protection. And can you give an example of where national law has or will go beyond the scope of the directive? And I'm just going to come back to Luca for that.
Yes, first of all, I have to premise that currently we only have a draft of transposition of the directive. So this draft could change quite a lot upon final approval. But according to this draft, the most significant aspect in which the Italian legislation could go beyond the provision of the direction will probably be the applicability of whistleblowing regulation also to companies with fewer than 50 employees, where these companies fall within the scope of the aforementioned legislative decree 231/2001. So we are going to have compulsory whistleblowing channels even in companies with less than 50 employees.
Okay, that's interesting to know. And Frank, how about in Amsterdam and Netherlands?
And the Netherlands.
Yeah.
Yeah, so a unique feature of Dutch whistleblowing law is that we have a kind of national whistleblowing authority, which is known ridiculously as the House for Whistleblowers. I can see some people laughing. The House has two tasks. So first, employees can turn to the House for advice about their position. And secondly, employees can ask the House to investigate wrongdoing and also to investigate whether the employer has retaliated against them. Now, the House was created in 2016, and due to understaffing and underfunding, the House has carried out only very few investigations. And yeah, there have also been incidents whereby employees of the House have blown the whistle about wrongdoing within the House, if you can still follow. And another hotly debated issue is that the House wears two hats, essentially. So it's both an advisor to whistleblowers and supposedly an independent investigator. And that raises many questions about fair play and conflicts of interest. I mean, can you really be an independent investigator if at the same time you are advising the whistleblower? Well, despite all these shortcomings, the powers of the House will be extended. In particular, the House will be able to impose fines if employers do not cooperate with investigations. So, for example, if you don't provide information or refuse to testify.
That's interesting. I'm not sure we've heard from a similar jurisdiction yet about a healthy whistleblower. So that's, yeah, really interesting to hear. Okay, and I think we've touched upon this in some of your answers already, but it's often a question that's asked when we talk about reporting. And I know the directive has left this to local laws to determine. So is anonymous reporting allowed under national legislation? And Telmac, I think you've already addressed this, but in Spain, can people report anonymously?
Yes, it will be possible. This is something new in Spain, and it's a little bit strange from a Spanish perspective, but yes, this will be perfectly possible. So we have to get used to it.
Yeah. And Frank, the Netherlands, can anonymous reporting take place?
Yeah, so it's the same here. You can now also report anonymously, and under the old law, no one really knew if this was permitted. So that has now been clarified.
Okay, so it's changed since the implementation.
Yeah, exactly.
Yeah. Okay, and Marcus, how about in Germany?
Yeah, same in Germany. Yeah, companies have to provide reporting channels that allow anonymous contact. That was basically one of the points why the Bundesrat, the federal states, the Assembly of the Federal States, denied the first draft law or criticized the first draft law, because it was clearly stated that companies have to provide for these anonymous reporting channels. But the latest draft law has foreseen this possibility.
Okay, great. And moving on to something that we actually get asked a lot about from our clients. So many of our clients operate with a centralised reporting system when it comes to whistleblowing. So they might have a compliance function that's managed at a group level, or investigations that take place at a group level, and so shared resourcing essentially. I know there's been a little bit of debate as to whether companies can share resources at a group level where they have 250 or more employees. So do you see any problems with sharing group resources, given the requirements of a directive to have local reporting channels? And how have your clients addressed this in practice? Telmac, from a Spanish perspective, are you able to touch upon this?
Yes, actually, it is perfectly possible to share their reporting system. So the companies within several companies within a company group can do that. However, it is important to note that in Spain, this might lead to eventually, under certain circumstances, it's not automatic, but this could lead to or be used as an argument to claim that the several companies or more, some of the entities, not only the employer, is a co-employer. So this is definitely a possibility, but we would advise to analyze whether this might have adverse consequences. It is not so much the case in multinational companies, but companies where it is not so clear that these entities are co-employers. It is important to verify whether this might create a liability from an employment perspective.
Marcus, can companies share group resources in Germany?
Yeah, just like Talmak said, it's within group companies, it's possible to have a centralized reporting system. And for Germany, I actually do not see the risk Talmak just outlined, a risk of co-employment. I cannot see that for Germany.
Okay, and Luca, how about in Italy?
Different to Germany and to Spain, as far as I know, as I heard. This is one of the issues that most worry Italian companies belonging to groups, especially if they are multinational. Currently, the draft legislation appears not to allow for a centralized reporting system, and conversely to require the establishment of separate whistleblowing systems proper to each company of a group, where these companies have employed in the last year an average of workers about above 249 employees. This solution has been very severe, very important, has been criticized, but in the position paper we wrote for AODV 231, which is an association, a big association in Italy, and bought by the Italian Confindustria, with another position paper dating January 2023, asking the Italian legislature, we all asked the Italian legislature for a provision that expressly enables this option. It has the faculty for the group to share the internal reporting channel and the related management. As I told you, we are awaiting the final enactment of the directive in a few days, and so perhaps in a few days this problem is going to be resolved. But until now, we advise clients to wait and to be very, very careful in sharing whistleblowing channels, because could be not allowed.
Yeah, and if it isn't allowed, I guess it's quite tricky because lots of companies and clients have those central systems set up already, so they'd need to change how they work and their procedures. So hopefully it will be permitted, but yeah, we'll see. I know that lots of countries also allow it's permitted as long as they can report locally as well. So we'll just see what happens in Italy and other countries, I guess. And I guess a similar theme in terms of global approach. So again, we've got lots of clients and contacts who have global whistleblowing policies or who want to implement global whistleblowing policies. And given the local variations in law when it comes to whistleblowing directive, do you think it's possible to have a global whistleblowing policy, or would you recommend local policies or maybe something in between? And Marcus, what do you think for Germany?
Yeah, I mean, usually it would be a good idea, I guess. On the other hand, I believe it will be quite difficult to implement one global policy. I mean, we've heard from the other colleagues that even though the underlying directive is the same, there are some nuances, some different approaches in the individual countries. Yeah, depending on the law, depending on the different cultural cultural system. So I unfortunately I unfortunately do not believe that a global policy will work. Maybe we can have some general policy which then has to be adapted and modified to the individual countries. But one global policy that fits all countries, I think, will be quite tricky, quite difficult.
Yeah, I think it can be tricky, can't it? Especially when there is such variations in law. What do you think, Tam?
Exactly.
From a Spanish perspective, Tam, what do you think?
Yes, I agree. I agree with Marcus. It's definitely useful to have a global policy that sets general framework, but it's going to be very difficult to have a global policy that works efficiently in Spain. Just an example of why this might be problematic, and this we have encountered this in the past, despite the fact that we didn't have a whistleblowing obligation. Many multinational companies already had their whistleblowing channels, internal reporting channels in Spain, and they had policies. And one of the things that these policies typically regulate is how the internal investigation must be carried out. And we have very specific regulations in Spain as to how this internal investigation needs to be carried out, who must participate, and this is sometimes regulated by the collective bargaining agreement that is applicable within a sector. So we often have a mismatch between the global policy and the local one, and even when this global policy is adapted to the country, it is done in a way that doesn't really take into account the national laws. So I think it is extremely important to adapt global policies to each jurisdiction to make sure that they can be used effectively. Otherwise, we have global policies that are supposed to be applicable. One of the main things we want is to apply those global policies, to abide to the policy, but we cannot do it because we have local legislation that says that we have to do the contrary or something different. I think there's a challenge for lawyers, and I think it's definitely very important to adapt the general framework.
Yeah, it's interesting, isn't it? Because I wonder whether companies would think that the directive would help to have a global policy because we have one standard that everyone needs to apply. But as we've heard today and in our first session, there is just local variations. What about in the Netherlands, Frank? What do you think?
Yeah, for one side, I agree with Marcus and Telmac. So most of our clients with international operations have a global whistleblowing policy. If you have a global policy in combination with country-specific rules, usually as an addendum to the policy, that is perfectly fine. But if you have a standalone global policy without country-specific rules, that is not permitted because you must have a written policy which is fully compliant with Dutch law. And then most clients ask, are there any sanctions? And well, no, but every employee can go to court and ask for an injunction, which would require you to implement a local Dutch policy.
Okay, great. And out of interest, even though the directive is only very recently come in, or if it's yet to be transposed, have your clients been asking to put in place policies to comply with the directive already? Frank?
Yeah, well, it's in the Netherlands, clients have time until December to implement their new policies, but we've received the first requests.
Yeah, okay, great. And I'm just going to pick up on a couple of questions that have come through from our audience. Is there a certain way in which the directive needs reports need to be made under the directive? So, for example, in writing or verbally? Marcus, do you know anything about that in Germany? Is there any kind of set rules as to?
Yeah, well, Germany was the latest draft has foreseen the possibility to do it via telephone, to do it in writing, but also to give the opportunity to do it in person. So you have a broad variety of how to report any wrongdoing. So yeah, no form requirement really. Everything is possible.
Okay, and Luca, is that the same in Italy?
Yes, it is exactly the same in Italy. No formal requirements. All solution can be good, even with talks personal talks. The only things we need now, until now, and I think even in the future, is that there should be more than one channel. There must be an informatic channel with specific safeguards from the privacy point of view, and there should be even other channel, for example, for sending letters or other kind of transmissions of reports. So everything is allowed, even anonymous.
I think that's probably similar in the Netherlands and Spain, is it, Talmac?
It definitely is. The main thing is that the employee or whoever or whistleblower has any channel available to report. So to make sure that there's no barrier to reporting. That's the same.
Yeah, and Frank, unless you're going to tell me different in the Netherlands, I'll skip you on that one.
It's the same here. So anything goes from a long letter to a quick chat, and if it's not in writing, then as an employer you must summarize it in writing to the whistleblower.
Yeah, okay. And what, in terms of, so who can be sued for retaliating against a whistleblower? From a UK perspective, I know that if an employer dismisses or subjects any individual who's blown the whistle to retaliation, then the individual can sue the company. But if the individuals have also been subjecting them to a detriment, they can also sue the individual personally. Is that the same in your jurisdictions? Frank, is that the same in the Netherlands?
Yeah, you can. In theory, you can sue a coworker if that coworker would retaliate against you as a whistleblower, but that coworker can legally hide behind the employer. So if the legal proceedings would end up in damages being awarded, then it would be the employer who pays the bill and not the coworker.
So there's no personal liability on the individuals. They don't pay themselves, the coworker.
Well, in theory, but they can just bring in the employer, and then the employer has to pay because they are subjected to the employer essentially.
Okay, that's interesting. What about in Spain, Tom?
This is different in Spain. We still have to see how courts deal with it, but typically in a harassment case in Spain, the individual, the employee that has committed a wrongful act, or that has that is responsible for, in this case, the retaliation, would be a party to the proceedings. He could be liable. He could be also liable for the retaliation. So it's not like in the Netherlands. We have a possibility. It's not common, and we still need to see how courts interpret it. But potentially, we anticipate that this will be possible. Not usual, but possible.
Okay, and Luca, is that the same in Italy? I think I saw you nodding at one point.
It's more or less the same as in Spain. We have to distinguish if the action is for reinstatement upon voidness of the retaliation. The counterpart is, of course, the company, the employer. But if the action is for compensation, there is joint and several responsibility, liability, both for the employer and for the colleague, in case, even if employee usually prefer to sue the employer, which is perhaps more wealthy and can pay better than the colleague in case of compensation.
Yeah, that's similar here. So, and in Germany, Marcus, is that also the case?
Yeah, in Germany. So if the whistleblower if the whistleblower's rights are violated due to the prohibition of reprisals, then the whistleblower could claim damages against the employer. On the other hand, if a whistleblower makes false accusations and the employer knows who did it, then the whistleblower is subject to claim for damages. But there are also fines. So employers can be fined if they do not put in place the whistleblowing hotlines, or if they don't maintain confidentiality. So it's pretty much similar as in the other countries.
Oh, okay, so those fines are more sanctions for not complying with whistleblowing laws on companies.
Yeah, those fines are from an authority level, and the damages are the whistleblower files a claim for damages against the employer, or vice versa, while the fines are imposed from the authorities.
Okay, that's interesting. So just whilst we're on sanctions, if your jurisdiction fails to put in place relevant systems under whistleblowing law, is there sanctions on the companies in your jurisdiction? Luca, are there any sanctions in Italy for not complying?
Until now, no, as I told you, because until now we do not have a compulsory whistleblowing system apart from 231 in Word. But the draft of the legislative decree transposing the directive is will provide for quite harsh sanctions upon the employer in case of not enacting the whistleblowing channels and so on, or for obstacle to the reporting of people. So until 50,000 euro for each breach, in addition to compensatory damages in case of other breach and disciplinary sanctions. What I'd like to point out is that in Italy, the transposing draft is going to implement a quite strong protection for the whistleblower, but not as well as for the reported person. The protection of the reported person is almost absent in the current draft of the legislative decree transposing the directive. And this is, we think, not compliant with Article 23 of the directive, which calls for effective sanctions to dissuade the whistleblower from carrying out with willful misconduct or gross negligence reports that turn out to be false or unfounded. This is a lack of the current draft of the legislative decree transposing the directive, but perhaps this lack will be overpassed in the final version.
That's interesting. So there's no the protection for the whistleblower, but if they act if they're disingenuous in their whistleblowing, then there's no sanctions on them in that case. It doesn't protect the person who's being reported. Frank, what about in the Netherlands? Is there any sanctions for failure to comply?
Yeah, so what I mentioned earlier, employers have until December of this year to implement a new whistleblowing policies, and if they fail to do so, there is no specific sanctions. However, employees can go to court and ask the court for an order which requires the employer to implement a policy. It is a very simple procedure, so it's probably only a matter of time before you are forced to implement a policy if you don't do so voluntarily.
Okay, that's interesting. We're definitely seeing lots of clients have whistleblowing procedures in place with third-party providers, and they just seem easy to do. I don't know if you're seeing the same, but I think whistleblowing hotlines via third parties seem to be the easiest way of complying because they're all set up in terms of that.
Yeah, definitely.
And so, what are the difficulties or challenges of companies, or will companies face with the implementation of the directive? Or can you think of anything of that might face companies in terms of struggles? Talmac, is there anything you can think of in Spain?
Yes, I think actually now that you ask about the challenges, I think the big challenge in Spain will be the sanctions, because we have a very heavy regime of sanctions. So I think in Spain it will be difficult to implement because especially for companies that are between 50 and 250 employees. 50 and 150 employees, it's not a big company, so the amount of resources that will be necessary, not in implementing the reporting channel, which is already quite burdensome, but to manage it. So we expect a lot of work managing the channel, and because we expect employees to make a lot of use of the internal channel. In our experience, once the channel is set up, it creates a lot of reporting. There is a lot of fraudulent reporting, and there is a lot of non-substantial reporting. So the work of dealing with that amount of reporting will be particularly challenging. I wanted to say regarding sanctions, Spain also has an independent authority. It's not called a whistleblower. It doesn't have a fancy name like in the Netherlands, but this independent authority has been created specifically, and I think this is the main purpose, to sanction. Not here, they will not provide any advice about implementation. They will simply sanction companies that do not have a reporting channel. And what is interesting is we have the employees will use these sanctions as leverage to force companies to in claims, or to negotiate with companies in claims that have nothing to do with whistleblowing, because these sanctions can go up to 1 million euros, and if it's above 600,000 euros, it can be published it needs to be published in the official journal. So this will be a lot of negative publicity, and on top of it, this can include as a sanction prohibition to enter into public contracts, which are sometimes much more valuable than 1 million euros, as we all are aware of. So I think this will be a huge headache for mid-sized companies, because implementing the whistleblowing channel will be very problematic for them, given to the structure that they have in terms of HR. And on top of it, if they don't do it, this is going to be used as ammunition by employees to constantly obtain better deals. Negotiations are totally unrelated.
That's really, really interesting. How about in the Netherlands, Frank?
Yeah, I think here the most important challenge is that whistleblowing policies require prior works council consent, or in case of smaller organization, prior consent from the staff representation committee. So you'll need to agree everything up front with the works council or the committee.
Okay. And Marcus, have you got any similar difficulties in Germany, or is there anything else you think is going to be?
Yeah, due to the fact that we do not have the draft law on the table, it is a bit difficult for the companies to really know what will be the final law look like, and so there is quite some legal uncertainty around the whistleblowing legislation. But I also agree with Frank that if a company has a works council, this is also a point where difficulties, challenges could appear. And I also see Talmac's point that some employees could try to use the fines for companies as a threat to basically yeah, be in a better position if they have any other case with their employer. So yeah, it's a bit of a mix of what Frank said and what Talmak said. I see these points for Germany as well, and again, the legal uncertainty that is currently here due to the lack of the law is quite huge at the moment.
Thanks, Marcus. Luca, do you think that's similar for Italy, given the position they're in now?
Yes, it's more or less similar. What is quite important that the small and medium-sized company will be obliged to adopt management whistleblowing channels and management procedures with all related fulfillments, which is not the case up to date, because as you know, as I told you, only companies falling into the scope of 231 legislative decree are obliged to adopt the whistleblowing channels. So all medium, all companies and will be obliged, and small and medium size will be obliged, as they are not until now. And even companies with companies that already have whistleblowing channels are going to be obliged to change this channel, to change the procedures for managing these channels. So this is a quite important challenge for every kind of companies in Italy.
Okay, great. I'm just checking our question box. We don't have any further questions. So just a reminder to our audience, if you do have any questions, just pop them in and we'll address them. But before we finish, do you have any kind of concluding remarks, any practical tips for our audience? Talmak, we'll go to you first.
Well, just to summarize a little bit what this is going to be about in Spain, I think companies that are thinking of not complying with the directive, with the Whistleblowers Act, they need to expect to have a lot of vulnerabilities that will be very relevant in certain negotiations, because the potential for sanctions is high. It's still to be seen how this plays out. And on the other hand, if companies are willing to comply or are thinking of complying, I think it's very important to adapt the global policy to Spain, and to expect a lot of work managing the whistleblowing channel. There's going to be a lot of reporting, in my view.
Sounds like that's the case. Luca, the Netherlands.
Italy.
Sorry, I was looking at you, Frank, and saying Luca.
Okay. Then I'll start. Yeah, I mean, as a practical takeaway, I would say make sure that reports of wrongdoing are identified as such and escalated to the proper channel or proper people within the organization. Otherwise, accidents will happen. We've seen examples of not so clever line managers telling off whistleblowers and saying things like, "I'm not even going to respond to your nonsense." So that's not good.
Great. And Luca, Italy.
Just to summarize, I think that the enactment of the directive will involve not only juridical issues, but even mainly cultural issues to change the mind of many people in Italy, which I told you were reluctant to accept the whistleblowing systems and to report misconduct or crimes. So I think that there will be not only a big change in the juridical game, but even in the cultural game.
Yeah, that'll be interesting to see. We'll look out for that. And Marcus, any final pearls of wisdom from Germany?
Yeah, I can only recommend all companies to use the time until the law finally will come into force, probably at the end of this year, to use that time to check how you want to introduce the channels, what kind of system you're going to use, and yeah, to make sure, as Frank already said, that yeah, reports are taken seriously and are dealt with in due time.
Okay, that's great. Well, that brings us to the end of today's session. Thanks very much, all of you, for joining us at home or in your offices, and thanks to our panelists today. I thought that was really, really useful. As I mentioned at the start, the session was recorded, so we'll be circulating that after this. But if you do have any questions or want to follow up with any of us, just get in touch. But thanks very much for joining us.
Thank you. Bye-bye.